So let's talk about what happens when a federal trial goes completely off the rails. I mean, so off that U.S. Marshals, on a judge's direct order, literally seal the courtroom and detain the entire defense team. This wasn't just a moment of drama. This was something else entirely. And it all boiled down to these two words. When the lead defense attorney stood up and said, "Your Honor, you cannot." The judge, Marcus Caldwell, didn't even blink. He just cut him off with that ice-cold reply, "I can." That's a moment that's going to be talked about in law schools for a very, very long time. And let's be crystal clear about what this was. This was a physical takeover. U.S. Marshals moved in, blocked every single exit, surrounded the defense table, and just took control. The attorneys were told in no uncertain terms, you stay put, you don't touch a single document, and you don't talk to anyone. Okay, so how on earth does a high-stakes, white-collar fraud trial suddenly turn into something that looks more like a tactical operation? Well, the whole thing went down in less than 90 seconds, and it was all set off by one explosive leak. Now, the guy who gave this order, Judge Caldwell, is the absolute last person you'd expect this from. We're talking about a 23-year veteran of the federal bench. This is a man who's seen everything: cartel kingpins, terrorists, you name it. People who watch him for a living call him unflappable, the calmest guy in the room. So for him to do this, well, it tells you the provocation had to be completely off the charts. And just look at how fast this all happened. It was like clockwork. The second Judge Caldwell uttered the word criminality, the marshals were already moving. This was obviously pre-planned. And that 11-second silence, can you imagine? That's the moment when everyone in that room realized this wasn't just some stern warning. The trial, as they knew it, was completely over. So the big question is, what could possibly justify this? What could push a judge to take such an extreme, unprecedented step? Well, the answer arrived just 47 minutes before that lockdown. It was a devastating leak, one that exposed an alleged criminal conspiracy happening right there at the defense table. All right, let's get into the evidence that just blew this entire case wide open, the Witness 14 recordings. These tapes are the reason a federal judge basically declared war on a team of lawyers in his own courtroom. You see, Witness 14 was the prosecution's whole case. They were the ace up their sleeve. This was an insider who had direct knowledge of fake documents, hidden bank accounts, the whole shebang. A multi-billion-dollar fraud that wiped out the pensions of thousands of ordinary workers. This witness was absolutely everything. So this is the first recording that surfaced from 11 days before the trial. It's what prosecutors would call textbook witness coaching. You can hear a voice telling the key witness to just be confused on the stand. It's a direct instruction to obscure the truth. Then, just a few days later, the second call comes, and this is where it escalates. Legal analysts look at this and call it blatant witness intimidation. That little mention of the witness's family's situation, well, that's not so thinly veiled threat. It's designed to terrify them into silence. And then came the final act, just 72 hours before the witness was supposed to take the stand. They weren't just coaching or intimidating anymore. No. They allegedly scripted the entire testimony and then threatened to blow up the witness's federal protection agreement. This right here, this is almost certainly what sent Judge Caldwell over the edge. But here's the real twist, the killer detail. These recordings didn't come from the prosecution or the FBI. No, they were leaked from inside the defense team itself. It seems somebody on their own team decided that avoiding a long prison sentence was more important than loyalty, and they set fire to the whole operation. So just to recap, we've got an internal leak, absolutely damning audio recordings, and a courtroom under lockdown. The fallout from this was immediate. It was catastrophic, and frankly, it is still sending shockwaves through the entire legal community. Think about this for a second. The very lawyers who were there to defend a client are now facing serious criminal charges themselves. We're talking about obstruction of justice, witness tampering, conspiracy, the works. If they get convicted, they are looking at more than 15 years in a federal prison. And the ripple effect is just massive. The law firm at the heart of all this, Morrison & Mercer, had 17 other active cases in federal court. Every single one of those is now under a microscope, facing motions for mistrials and reviews for any other potential misconduct. But it goes way beyond just the individual lawyers or their other cases. The firm itself, this historic institution, is facing a true existential threat.
This isn't just about losing a case. It's about the very real chance of the firm's complete and total collapse from disbarment proceedings and just overwhelming liability. Morrison and Mercer could literally just cease to exist. Now, you'd think, when faced with this kind of career-ending evidence, you'd be careful, right? Well, the defense team's first move was just astonishing. Instead of even trying to address the tapes, they went on the attack against the judge. I saw one former federal prosecutor call this statement professional suicide. I mean, can you imagine blaming the judge just hours after audio of your team allegedly tampering with witnesses goes public? It's unreal. So why are people calling this a historic moment? Well, legal scholars are arguing that this wasn't just another bit of courtroom drama. No, this was a fundamental stress test of the entire justice system, and it may have just set a powerful and very necessary new precedent. You know, people have tried to compare this to the chaos of the Chicago 7 trial or the corruption of Watergate, but there are some really critical differences. In Chicago, it was all about the defendant's actions. In Watergate, it was political operatives. Here, we're talking about sworn officers of the court. And the biggest difference of all, the one that changes everything? Undeniable, time-stamped, voice-print matched audio recordings. And that's exactly what Professor Thornton is getting at here. Technology just changes the game. For years, witness tampering has been one of the hardest things to prove. It was always one person's word against another's. But this case proves that when the evidence of corruption is this explicit, this undeniable, the system has to respond with an equal amount of force. And you can see that equivalent force justified in the very specific language the judge used. He said he was acting to preserve the integrity of evidence. Now, that's not a phrase you use for a simple disagreement. That's what you say when you believe a crime is literally in progress, and the proof is sitting right there in front of you. He wasn't looking at a defense team anymore. He was looking at an active crime scene. So, at the end of the day, Judge Caldwell sent a message that is going to echo through every single law firm in this country. And the message is this: aggressive advocacy for your client is one thing. That's protected. But using your law degree and your position as an officer of the court to commit a crime, that's a threat to the entire system, and it will be neutralized. And that leaves us with one final critical question. We hear all the time about how the rich and powerful can get away with things. So was this a real turning point? A sign that maybe the system actually can police itself? Or was this just a shocking, rare exception that actually proves the rule, that in most cases, justice is delayed or maybe even denied? The answer to that is still unfolding.